under William Howard Taft. They asked themselves, it is a fundamental right under the American Constitution to be tried by a jury of one's peers. And they said, we are now extending our Bill of Rights to this new colony of ours out there in the Pacific. Initially, they couldn't even find the Philippines on the map. And they said, no, it's not going to work in the Philippines. Everybody there is related to one another. Everybody is a second cousin of his closest neighbor. And by the way, I agree with that evaluation. A jury trial will not work in the Philippines. But all our rules assume that the jury has to be insulated from improper evidence. The best evidence rule, the hearsay evidence rule, we all derive this from the US. And what is the solution of the Filipino judge? And I discovered this as a young lawyer. I will object and the judge will say, admitted for what it's worth. I wanted to tell the guy, it's not supposed to be worth anything. But you see, he followed the intuition that he doesn't have to be protected from improper evidence because he is a trained lawyer and a trained judge. Well, that is at the heart of the dilemma of the debates before the ICC. And that is a debate which is like second nature for Filipinos. I would like to proceed to the last two issues. The next is, it is a concern especially of the major funders of the ICC, the major contributors financially, that the trials are dragging on too long. The presentation of evidence indeed takes a long time. There is a duplication of the presentation of evidence. First at the level of the prosecutor, and then at the level of the court. Well, if the problem is judicial delay, Filipinos are experts at judicial delay. In fact, there was a case that at the height of the anti-Marcos struggle, the election between Cory Aquino and Marcos, the Aquino supporter, governor of Antique, was murdered right in the provincial capital by a warlord, Arturo Pacificador. His son, who was charged with murder, sought refuge in Canada. And when we asked that he be sent back to Manila by extradition, Canada refused. They said, we really want to help you. But if the delay in your courts is this long, it is unconscionable by Canadian standards. We cannot send back the accused to Philippine courts. And we have grappled, as former dean of the law school, I have sat on endless planning committees to look at judicial delay in the Philippines. Oh, I have taken part in the EU program, the European Union Justice Reform Project, together with Professor Roque, the EP Just program to deal with all the bottlenecks of the Philippine judicial system. We have developed our own jargon. We call it docket congestion, case flow management. We have procedure to address the problem. In fact, many of the problems faced by the ICC are problems we already face in the Philippines. The duplication of investigative work done by the National Bureau of Investigation and then redone in preliminary investigation by the prosecutor and then passed on to the court. We face that. It is also faced by the ICC. So if the problem is addressing judicial delay, I think the Philippines has a lot to contribute. Building from our own experience, building from our own experiments in the Philippines. Attempts that have worked, attempts that have not. For instance, I understand in the ICC the search is for ways to speed up the presentation of evidence, but without having to amend the rules of procedure. Because amending the rules is a legislative act, it becomes very political. And of course, again, the civil law and the common law jurisdictions will have competing ideas. And in the Philippines, that is a problem we have dealt with. We say that, if the problem is to maximize the reception of evidence before actual trial, what we do is we use existing rules under the modes of discovery, and we subsume the reform under that. In other words, we depoliticize the reform, we facilitate and streamline the reform. Maximizing admissions. At the Nuremberg Tribunal, one critique of the American prosecutor, the famous Robert Jackson, was that it took him so much time to authenticate documents that it was actually getting so boring. And that happens in the Philippines. It happened during the impeachment of Chief Justice Renato Corona. We spent 1 week just to authenticate bank documents. Total waste of time. And that is something that can be avoided in the Philippines, can be avoided at the ICC. Which brings me now to the last point. Delay has a cost. And I agree that the cost of international justice is so high. And especially coming from the Philippines, we have so many basic needs of our people that are not met. We have families living under the bridges, and international justice is such a big expense. It is a problem that is heartfelt for Filipinos. But you see, the Philippines also offers the experience of impunity. In other words, if justice is expensive, just imagine the actual cost of impunity. And the historical record shows that Marcos was never held responsible in any court for human rights violations, for any court in the Philippines. He has never been held responsible, except in 2 courts. One in Seattle, one in Honolulu. In other words, when we regained our democracy in the Philippines, we failed to establish judicially the responsibility of Marcos. And the damage to our country, to our governance, actually to our national psyche is very deep. That we never had any closure on the Marcos era. In fact, I'm so glad that the Human Rights Claims Board members are here. Because yesterday I said that there was never any judicial closure. Your board is the only form of closure that we have. And it was by virtue of a legislative act. And even then, the legislative act was long debated by several Congresses. And in fact, for a long time, the impediment was even our own PCGG, which says that the money it recovers cannot be shared with the human rights victims. So, the metaphor for education is that if you think education is expensive, try ignorance. The same thing. If you think that international justice is expensive, look at the cost of impunity in the Philippines and the recurring nightmares that could have ought to have ended had we followed the example of many Latin American countries. Argentina had its Nunca Más program. The Never Again South Africa had its peace and reconciliation bodies. East Timor had its own truth commissions. The one time we had a truth commission in the Philippines, it was actually struck down by the Philippine Supreme Court, no less. And I think we should give credit to President Aquino, and I say that because President Aquino's representative is here, Undersecretary Popoy Pilando. Welcome Popoy. Because it took him, Executive Order number 1 of President Aquino was to form a Truth Commission. And the Supreme Court said, we're striking down the Truth Commission on the grounds of equal protection, because he focused just on one president. And my joke before my students is that, well, if that is the problem, the only valid Truth Commission is one that says that the Commission will have jurisdiction all the way to General Emilio Aguinaldo for the execution of Andres Bonifacio. In other words, a trial in pleading our foremost national heroes in the pantheon of Philippine history. So on that point, I thank everyone present this morning, and I hope you can join hands with us in this campaign. Thank you.